Hello friends, welcome to my channel. Friends, today we will look at fines under GDPR. Now friends, GDPR is considered one of the strictest regulation in the world, predominantly because of the hefty fines that it imposes in those cases where corporations have failed to comply with data protection regulations. The aim of GDPR is to ensure that individuals have a greater control over how their personal data is collected and processed. It also provides a remedy to the data subjects by holding the violators of their personal data to a very strict scrutiny and levying fines and penalties in cases where violations are found. Fines under GDPR are intended to have a deterrence effect on the businesses, irrespective of whether they are big or small. GDPR applies to the data controllers and data processors of big or small organizations and irrespective of whether they are based in Europe or not, as long as they process the data of European citizens. Friends, now let's look at the relevant provisions which talks about penalties under GDPR. Friends, Article 83 talks about general conditions for imposing administrative fines, wherein it empowers data protection authorities to impose administrative fines for non-compliance with the regulation. Now, what is the meaning of administrative fines under GDPR? Friends, administrative fine refers to monetary penalties, that is, penalties which have to be paid in the form of money. So, these monetary penalties are imposed by whom? They are imposed by the supervisory authorities of that country. Who are those supervisory authority? In this case, it would be the relevant data protection authority of the country, maybe of the region, etc. On whom will these penalties be imposed? These penalties will be imposed on organizations who do not comply with the provisions of GDPR. Now, these proceedings are purely administrative in nature and do not involve court or criminal proceedings, and that is why they are known as administrative fines. Now, friends, GDPR looks at violations in two forms: less severe violations and more severe violations. Those violations which fall in the category of less severity, they entail lesser administrative fines, and naturally more severe violations will incur higher penalties. And so, to address this differentiation, GDPR fines are also two-tiered. The first types of fines are fines which are up to 10 million euros or 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher. This is the lower level of penalty. The higher penalty are fines up to 20 million euros or 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher. So now, friends, we know why GDPR is one of the strictest regulation in the world, because of the extent of fines that can be imposed on organizations which do not comply with GDPR. Friends, let's look at the relevant provisions which, when violated by the data controllers or data processors, could result in fines up to 10 million euros or 2% of the total annual turnover. Number 1. Violations of the provisions under Article 8 of GDPR. Now, Article 8 deals with what conditions are necessary for processing of personal data of children, and more importantly, the process for obtaining a valid consent from children or their parents for processing of their data. Number 2. Any violation of provisions of Article 11 of GDPR. Now, what does Article 11 talk about? Article 11 allows for the processing of personal data that does not require any identification, provided that this data is kept separately and strict measures are in place to prevent re-identification of data subjects. Number 3, Article 25 to Article 39. Friends, these articles deal with the principles of data protection in significant detail. It talks about the rights of data subjects, the obligation of data controllers and data processors, data transfers to third countries or other international organizations, supervisory authorities, cooperation among EU member states, etc. Number 4, any violation in the obligations under Article 42 and 43 of GDPR. Friends, Article 42 and 43 provides that data controllers and data processors should consider using a certification mechanism to demonstrate that they are compliant with GDPR. It also obligates the certification body, that is, the body which is certifying compliance with GDPR, to be accredited by a supervisory authority so that they can carry out certification activities effectively. These provisions also provide that certification bodies should establish and apply certain certification criteria and procedures that align with GDPR's requirements so that they can assess and certify an organization's compliance properly. Number 5. Any violations under Article 41, Clause 4, which talks about the obligations of monitoring body to take actions in cases of infringement against the controllers and processors. Now friends, let's look at the second type of cases where fines up to 20 million euros or 4% of the gross annual turnover of the previous year, whichever is higher, would be imposed. This fine is generally given in more serious cases of violations. Let's look at the provisions which, when violated, could be considered serious violation and result in such severe penalties. Number 1. Violations of provisions under Article 5. Article 5 talks about the general principles like lawfulness, fairness, transparency, purpose limitation, data minimization, etc. that must be followed by data controllers and data processors while processing the personal data. Number 2. Any violation under Article 6 of GDPR, which talks about the 6 legal bases for data processing like consent, performance of a contract, legal obligations, etc. Number 3. Any violation of Article 7, which says that consent will be considered freely given only when it is specific, informed, and unambiguous. Any violation of Article 9 of GDPR that talks about processing of sensitive data, for example, any data that would reveal sexual orientation, ethnic origin, religious beliefs, or the biometric or genetic data or health data of data subjects. Friends, I have covered these articles in significant detail in another video, and I will paste a link in the description box so that you can go through it in case you are not aware about them in sufficient detail. Secondly, any violation that results in infringement of data subject's right would also be considered as a severe violation and entail significantly higher levels of penalties. Any violation of provision of Article 12 of GDPR would be considered a severe violation. And Article 12 talks about the right of data subjects to be informed about the processing of their personal data in a transparent, concise, and easy to understand manner. Any violation of Article 13 and 14 will also be considered severe. Both the articles talks about which kind of information and within what duration should controllers provide to data subjects whenever personal data is collected from them. The only difference is that Article 13 talks about a scenario where the data is directly collected from data subject, whereas Article 14 talks about a scenario where the data is not directly collected from data subject but is collected from other sources. Friends, similarly, any violation of the provision of Article 15, which gives the data subjects the right to access their personal data, or any violation of Article 16, which provides the data subjects the right to rectify their data in case their data is incorrect, or Article 17 violation, which talks about the right to be forgotten, now known as the right to data erasure, or a violation of Article 18, which empowers the data subject to restrict the processing of their personal data, or a violation of Article 19 that provides that data controllers must notify the recipients to whom data might be disclosed in case any changes under Article 16, 17, 18 of the data subject's data happens, and should be done within a reasonable time, and only would be considered a severe liability if it was possible to make these disclosures with reasonable effects and without requiring any disproportionate efforts on their side. Friends, any violation of the provision of Article 20 that talks about the right to data portability, and violation of Article 21 that gives the data subjects the right to object to the processing of their personal data under certain circumstances. For example, when the data is being used for direct marketing purposes. Article 22. This article empowers the data subject to refuse the automated processing of their personal data. So, when any of these violations happens on the rights of data subjects, it is considered as a severe violation, and it will be considered a serious violation, and the violators will be held responsible for penalties at the highest level and to the maximum possible extent. Similarly, friends, any violation of the provisions of Article 44 to 49 of GDPR, which deals with the transfer of personal data to a recipient in a third country or to an international organization. Any violation in fulfillment of obligations under Chapter 9 of GDPR, which deals with laws or regulations which are enacted by member states of EU to implement GDPR. Now, friends, member state law may provide for additional requirement measures or safeguards for the processing of personal data within their respective jurisdictions, as long as these jurisdictions are consistent and supplement GDPR and they do not undermine the protection of rights and freedoms that are granted to an individual under GDPR. This ensures that there is a broader uniform framework for data protection throughout Europe, and at the same time promotes specific considerations at the national level. Similarly, friends, any non-compliance under Article 58 Clause 1 and 2 of GDPR, what does it talk about? It deals with orders that are passed by a relevant authority, or where the supervisory authority has imposed a temporary or definite limitation on the processing of data, or has imposed a suspension on the flow of data. Any non-compliance with these orders could result in imposition of severe or higher level of penalties. Now, friends, we know the extent of monetary penalties that can be imposed on data violators. But still, the extent of actual monetary penalties can only be decided on a case-by-case basis. Now let's look at the different factors which the supervisory authority must take into consideration while deciding the fines that will be imposed. Let's look at the conditions of factors laid down in Article 83, Clause 2, based on which the fines would be imposed. Number 1. The authority would take into account the nature of infringement, the gravity of infringement, the duration of infringement, the scope or purpose of the processing concerned, the number of data subjects that are affected by this infringement, and the level of damage that is suffered by them. They will also take into consideration whether the infringement was intentional or negligent. They will also look into the different categories of personal data that were impacted by the infringement. And they will also consider whether any action was taken by the data controller or data processor to mitigate the damage suffered by data subjects. If yes, then such proactive measures to prevent or minimize harm can have a positive impact on the assessment of fines. They will also look into what extent are data controllers and processors responsible for the infringement. The authorities would also like to take into account the technical and organizational measures implemented by them under Article 25 and 32 of GDPR. Article 25 of GDPR focuses on data protection by design and default. This means that organizations implement such measures so as to ensure that the personal data of data subjects is protected throughout the data processing lifecycle. Article 32 talks about security of data processing and what measures data controllers and processors must implement both at a technical and an organizational level to ensure that a certain level of security which is suitable to the risks that are associated with data processing is ensured. They will also see whether the data controller or processor had a history of violations, and if that is found to be correct, then they might be considered as repeat offenders and fines could be on a higher side. The authorities will also take into consideration the degree or extent to which the processors and the data controllers are cooperating with them in order to remedy the infringement and mitigate the possible adverse effects of infringement. They will also take into consideration the manner in which the infringement became known to the supervisory authorities, especially to what extent did the controller or processor notify the infringement. They will also consider whether certain orders had been previously passed against the controller or processor with regard to the same subject matter in respect of compliance with those measures. Another thing that they will take into consideration is whether the data processor or controller ensured compliance under Article 40 of GDPR by adhering to an established code of conduct which is relevant to their industry or sector, thereby helping them demonstrate their commitment to privacy and data protection, or whether their organization obtained a certification or a seal of approval as regards their compliance after an independent assessment of their data protection practices under Article 42 of GDPR. The authorities would also like to take into consideration any other aggravating or mitigating factors that could be applicable to the circumstances of the case, such as financial benefits gained, losses avoided, directly or indirectly from the infringement. So friends, all these factors are taken into consideration by deciding the extent of fines or monetary penalty that would be imposed on violators. So friends, in this video we understood the two tiers of administrative fines under GDPR and the violations which would incur higher penalty versus those violations which would incur lower penalty. Even though the maximum limit in both the cases is extremely high, that is 10 million or 20 million euros or 2 or 4% of annual gross turnover, whichever is higher, the authorities have also been guided to take various factors into consideration before deciding the exact monetary penalty or fine that would be imposed. So friends, I hope you liked this video. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.